Okay, great. Is the court going to be made aware of that at some point in time?
Yes. I don't know how.
Yeah, I'm just going through what we have to take care of here today.
Sure. I don't know if the court wants to handle that before the sentencing or after.
I don't know what you're doing, so.
It's going to be an update of one of the counts.
Okay. We could do the plea if you want.
Okay.
Get it all done so we have one sentencing.
Sure. Judge, in case 660-140, the state of Ohio will amend count 2 to incorporate the name of the victim in count. It's also listed in count 3. So Dominique Haji, H-A-J-I, and the named victim in count 2 is Chanel, S-H-A-N-E-L-L, Backy, B-A-C-K-I-E. Count 2 is aggravated menacing. It's a misdemeanor of the first degree. It's punishable by up to 6 months of local incarceration and a $1,000 fine. It's the state's understanding the defendant will withdraw his previously under plea of not guilty, enter plea of guilty to amended count 2, and on condition of that forthcoming change of plea, the state will move to dismiss the rest of that indictment.
Okay. So representing the defendant at this time is Michael Parklow. He's present in the court. Michael, is that your understanding as well?
Yes, with the understanding that any time the vote will be
Correct. Okay. It's a misdemeanor, so by law, that's so, Mr. Washington, I need to ask you a series of questions. If you'll answer out loud, I would appreciate it. Sir, how old are you?
4.
How far did you go to school?
12th grade.
Can you read and write?
Yeah.
Understand what you're doing in court here today?
Yes.
Okay, you hear what the prosecutor said?
Yes.
You hear what your lawyer said?
Yes.
Okay, in order to accomplish that, it's necessary for you to waive or give up certain constitutional rights. They are as follows. You give up your right to a trial by jury.
Oh, yes.
You give up your right to have the state of Ohio prove you guilty beyond a reasonable doubt.
Yes.
Do you waive your right to subpoena witnesses that come to court for the
Yes.
trial of the arson case?
Yes.
Do you waive the right to have Mr. Partlow cross-examine the witnesses at the arson case because with your plea there'll be no trial?
Yes.
Okay. Are you presently on probation, parole, community
No.
control sanction, or post-release control for any other case?
No.
Okay. You understand that no prison sentence will be imposed on this and any sentence you receive will be concurrent?
Yes.
Okay. The only sentence you get is up to 180 days in the county jail and up to a $1,000 fine. Do you understand that?
Yes.
Okay, great. You understand that the amendment that was made here was to include the name of nominee Taj to count number 2 of the indictment?
Yes.
Okay, great. Are you satisfied with Rule 11?
Yes, Your Honor.
Michael?
Yes, sir.
You satisfied? I comply with Rule 11? Okay. So then, Bennie Washington, let me ask you, how do you plead to amended count 2, which is now amended with the inclusion of the name nominee Taj, a misdemeanor of the first degree of aggravated menacing in violation of 2903.21A?
Guilty.
Okay, let the record reflect the court finds that the defendant has knowingly, voluntarily, for full understanding of his rights, entered his change of plea to guilty. The court accepts that plea, makes a finding of guilt, and on the recommendation of the prosecutor's office, annuls the other counts. All right, now that we have that, then you guys can sit down. Thank you. Folks, we're here for purposes of sentencing today, and as we get into the sentencing hearing, I would like to read you the duties that are imposed upon the trial court when imposing sentence. So I would start off by saying is that I will listen to everything that's said here in court today, especially the victim impact statement, if any. There has been a trial of this matter, and the court, I think, listened pretty closely as to the evidence that was produced at trial. And I have to formulate my decision based upon the overriding principles and purposes of felony sentencing, namely to protect the public from future crime by the defendant or others, and to punish the offender using the minimum sanctions that the court finds will accomplish those purposes without imposing an unnecessary burden on state or local government resources. To achieve these purposes, the court has considered the need for incapacitation, deterrence, rehabilitation, and providing for restitution. The court must and will consider the seriousness and recidivism factors relevant to the offense and the offender pursuant to 292912. The court will ensure that the sentence being imposed does not demean the seriousness of the crime and the impact it has on the victim and is consistent with other similar offenses committed by like offenders. Finally, the sentence is not based on any impermissible purposes, namely the race, ethnic background, gender, or religion of Mr. Washington. Do you understand that, Mr. Washington?
Yes.
Okay. So over at the council table for the state of Ohio, I forgot to introduce you, I apologize. We have Assistant County Prosecutors Christian Carcutt and Jasmine Jackson. The record would reflect back on May 24th, the jury returned verdicts of guilty to count 3 and 5, which were murder, count 7, felonious assault, count 8, felonious assault, count 9, abuse of a corpse, and the defendant had waived count number 10 of the indictment, having a weapon under disability, and the court found the defendant guilty of having a weapon under a disability later on in that proceeding. Counts 3, 5, 7, and 8 carry a 1-year firearm specification, a 3-year firearm specification, a 54-month firearm specification, and there also is a notice of prior conviction and a repeat violent offender specification. Based upon the court's reading, it's my understanding, I would say that courts 3, 5, 7, and 8 merge. Does the state of Ohio want to elect what count number it wants to go under?
We do, Judge. I agree that all of those counts do merge for the purposes of sentencing. We elect that the defendant be sentenced on count 3. Counts 9 and 10 are now subject to the jury.
Okay, great. All right.
All of the firearm specifications merge with one another. We elect that the defendant be sentenced on a 54-month firearm specification.
Okay, great. All right. And that being said, I'll turn it over. Does the defense have anything to say before I turn it over for victim impact?
No.
Okay, and I understand that the defendant has a Fifth Amendment right, and that probably was advised by counsel of that, but it's duty bound upon me to make that request. With that being said, I'll turn it over to the state of Ohio for its presentation here this morning.
Thank you, Your Honor. I know that the court paid particular close attention to the facts and evidence in this case. The court was also a trier of fact as to certain charges in the indictment and specifications. Today has been a really long time coming for the family of Adriana Barnes. Not only did they wait 7.5 months to find her body, to have her brought home in the condition that she was in at the defendant's hands, and that's not something that's alleged, it's something that this jury determined during the course of the trial. So today's been a day that this family has waited quite some time for. I also filed a sentencing memorandum to aid the court in its sentencing this morning. And there's some things I want to highlight for the court with respect to that memorandum. As I indicated, we elect on count 3. The state of Ohio is asking this court also to impose consecutive sentences in a sentence pursuant to the repeat violent offender specification that this court found the defendant guilty of. A moment ago, Your Honor, you talked about what the purposes and principles of felony sentencing are, and the fact that, like or similar cases, you have to look at the sentencing in regards to how this offender is treated and in light of those other cases. And I hate to say that this is just not your typical case in the city of Cleveland. We don't find young 18-year-old women having decomposed and rotted on their ex-boyfriend's porch or their boyfriend's porch for 7 months. The harm imposed not only on the community here and on the victim's family is so great and unusual. You know, there was a community effort to find this young woman. There was an effort on behalf of her mother, day after day after day, looking for her daughter. And the psychological torture that this defendant inflicted upon this woman and her family is just insurmountable and not seen in any other case. You know, these detectives, someone gets shot in the middle of the night and they go to the home of the victim's family and they knock on the door and that's their notification. Adriana's mom didn't have that. She went to this location day after day hoping to find her daughter. And that's just so egregious. I mean, he would call her. He would reach out to her. He would ask her for rides. He asked her for money. He went looking. He took her looking for Adriana, knowing full well where she was for 7.5 months. It is a case that is so great and unusual that it requires this court, I think, to impose that additional time for the repeat violent offender specification. So also, pursuant to 29 14B1G, the firearm specifications. Pursuant to that section, if an offender is found guilty of murder and felonious assault, the court is required to impose a sentence for the two most serious firearm specifications. Those are 54 months here. So you add 54 months and 54 months and you get 9 years. Now, even though that 54-month firearm specification is attached to felonious assault pursuant to the Ohio Supreme Court's decision in Baller, this court can run those two firearm specifications consecutive to each other, consecutive to the life sentence for murder, which is life with parole eligibility after 15 years. That gets us to 24. The state's asking that you impose a consecutive sentence for abuse of a corpse. That's 1 year. A consecutive sentence for weapons under disability, which is 3 years, and that gets you to 28. And then this court can impose up to an additional 10 years for that repeat violent offender specification. If there's ever been a case that deserves it, it's this one. And I ask that you impose a sentence of life with parole eligibility after 38 years. The family would like to address the court now.
We've done this in the past. When you come up, tell us your name, spell your last name for the record, please, ma'am.
My name is Latoya Clark, LATOYA-CLARK. I'm Adriana Barnes' auntie.
Ms. Clark.
I didn't even know what to say, but knowing that a coward actually killed my niece, like, it's just still shocking for me, her siblings, and the kids. Like, I don't understand. Like, I don't get it. Like, you're way older. She's a baby. You killed a baby. There's nothing in this world, nothing on this earth that an 18-year-old can do to a 40-year-old for you to kill her. You're a coward, and I hope you get everything you deserve.
Thank you, Ms. Clark. Ma'am, please state your name for the record, please.
Akua Avignon. AKUA. Last name is AVEGNON.
Ma'am, I have a hard time hearing you. I just want to let you know. I want to hear everything that you say, but you're going to have to speak a little bit louder.
Okay. Akua Avignon. AKUA AVEGNON.
Okay.
Words cannot express how hard this is for me. You took her away in a matter of seconds. It took me 10 hours, 21 minutes to bring her into this world. In a matter of seconds, you took her because she no longer wanted to be with you, because you're a pedophile and you're a disgusting person. You called my phone every day to say, we're gonna find her, we're gonna make sure she come back. You stood in the kitchen and said, I miss her and my baby. But yet you took her knowing that she was pregnant, without a care, because you're a disgusting individual. One of the proudest moments was her graduation. She graduated at 17. Deciding to go to the military wasn't something that she just did on a whim. She's been wanting to be in the military since she was in the 9th grade. I regret not allowing her to start in the 10th grade when they offered her that chance, because she was on the track to graduate early. Then she wouldn't have never came across your path. I hope every time you close your eyes, you see her. Every time it's quiet, you hear crying. You deserve everything that you're going to get. You are disgusting. You helped me look for her. You called every day, just checking on you, making sure you okay. We gonna find her. When all the while you knew what you did to her. You knew. But you just kept calling me. You kept saying, oh, she coming home. When you knew she wasn't. You disgusting.
Thank you, ma'am.
Judge, just one more thing with respect to the defendant's criminal history and the recidivism factors as they pertain to Mr. Washington. You know, the reason there are these 54-month firearm specifications and a repeat violent offender specification on these indictments is because he's previously shot a woman in the past, and he went to trial and he got a 7-year prison sentence, and clearly that wasn't enough to deter him to change his behavior to conform with the laws of the state of Ohio. And I'd ask the court that you consider that. I mean, he got firearms, had access to firearms, and here we are again. And the outcome was much, much worse. So again, I'd ask the court to impose the sentence as outlined in my sentencing memorandum. Thank you.
Thank you. As a portion of the trial, I should reflect for the record that we're at sentencing right here. As to counts 3, 5, 7, and 8, the defendant at his trial waived his right to a jury trial on the gun specifications of 1 year, 3 year, and the 54-month specification, and also waived the notice of prior conviction specification and the repeat violent offender specification, to which the court returned verdicts of guilty after the jury had returned its verdict. So now it becomes incumbent upon the court to pronounce a sentence, but in doing so, I would just like to review. I started off with what the principles and purposes of felony sentencing are, and it's a balancing test to protect the public and to punish the offender from future crime. And the prosecutor just said before she sat down, was that she had this defendant here had shot a woman before and received 7 years in prison for it, and still came back out again, and this time he killed. So in going through the process that I have to go through, I have to review under 2929.12b the conduct more serious, and I would say that the injury was exasperated by the victim's physical or mental condition or age. She was a young woman, and this man was nearly twice her age when this crime occurred. And the fact of the matter is that the victim's relationship with the victim, the offender's relationship with the victim facilitated the offense. He took her in, and then he did what he did to her. In reviewing section 2929.12c, I find no factors that would apply to the offender's conduct being less serious. Pursuant to 2929.12d, the court has to make a finding about offender's recidivism more likely. And I would say that the offender has a history of criminal convictions. Obviously, he didn't respond favorably to sanctions previously imposed because he shot another woman, thereby taking this young lady's life. And I would indicate, based upon the facts that I listened to during the course of the trial, the offender shows no genuine remorse. Pursuant to 2929.12e, the court looks and tries to find the offender's recidivism less likely, and I find no factors that would apply to that. In pronouncing a sentence, the court has to use those factors so that it's not a sentence that just comes out of the air. I go through the process that the law charges me with. So as to count 3, murder in violation of 2903.02a, the court finds sentences the defendant to 15 years to life as to the substantive count of the indictment. The court imposes a 54-month sentence in prison for a violation of 2941.145d, and that has to run consecutive to the underlying crime. Further, the court sentences the defendant to 54 months in prison for a violation of 2941.145d, which is the gun specification contained in both the felonious assault and other murder charge, and I do so based upon State versus Bollar, B-O-L-L-A-R, and that's 2022-Ohio-4730, which instructs the trial court that that's the way the sentence is to be imposed. As to count 9, gross abuse of a corpse, a felony of the 5th degree, the court imposes a sentence of 12 months. As to count 10, having a weapon under disability, a felony of the 3rd degree, pursuant to 2923.13a2, the defendant is sentenced to a term of 36 months. Lastly, the court recognizes the jury returned a verdict of guilty to the notice of prior conviction and to the repeat violent offender specification. The notice of prior conviction details a felony of the 2nd degree, which is felonious assault, and it's going to be found at case number 539398. The court finds that the prison term imposed pursuant to the sentencing statutes would be inadequate unless the court imposed an additional sentence under the repeat violent offender specification. It needs to do so in order to protect the public from future crime by this defendant. As I indicated, his likelihood of recidivism outweighs any of the applicable factors under the section indicating a lesser likelihood of recidivism. The court finds that a prison term imposed pursuant to Division B2A3 of this section are demeaning to the seriousness of the offense because one or more of the factors under Revised Code 2912, indicating the offender's conduct is more serious than conduct normally constituting the offense are present. They outweigh the applicable factors of the section indicating the offender's conduct as less serious than the conduct normally constituting the offense. The court finds that it is necessary to impose this additional sentence under the repeat violent offender specification because the present sentence is inadequate to punish the offender and to protect the public. As to consecutive sentencing, the court finds that consecutive sentences are necessary to protect the public again from future crime and to punish the offender, and that the consecutive sentencings are not disproportionate to the seriousness of the offender's conduct and to the danger the offender poses to the public. And the court also finds one of the following. That the offenses were committed were so great or unusual that no single prison term for any of the offenses is committed as a part of this course of conduct adequately reflect the seriousness of the offender's conduct. Lastly, the offender's history of conduct, that being criminal conduct, demonstrate that consecutive sentencings are necessary to protect the public from future crime committed by this offender. Having said that, the court is also in receipt of a document which is referred to as an affidavit of indigency under mandatory fine provisions, and that it says that, but it's for purpose of indigency, and I acknowledge that on the record. And it's indicated that Bennie Washington has no real estate, stocks or bonds, bank accounts, cash, or automobiles, and he has no liquid assets. And I think that I will make a finding at this time that the defendant is indigent for purposes of appeal, and we'll talk about that shortly. Anybody want to be heard on the misdemeanor case?
Judge, no, there's no additional sentence.
Right.
It's going to be imposed on that. A couple things.
Sure. I want to be heard.
Yeah, well, he needs to, there should be a form the court has, the violent offender form
I don't have that in
for
front
the
of me.
murder. And then just so the record is clear, the jury had the first two firearm specifications in front of them, the 1 and 3 year, but they're not referred to that when the jury made those decisions. And the court had the 54-month and the RTO.
Oh, okay, yes, I agree. I agree with that. Okay, I have in front of me a notice of a duty to enroll as a violent offender pursuant to 2903.41 and the statutes that follow thereafter. It indicates the county of conviction is Cuyahoga. The case number is 668858. The conviction is for murder in violation of 2903.02A. And it's titled Washington, last name Bennie, first name. You have been convicted or pleaded guilty to a qualifying offense as defined in 2903.41. If you are not sentenced to a prison term, you are required to enroll in the violent offender database personally with the sheriff of the county in which you reside 10 days after being sentenced. If you were sentenced to a prison term, you must enroll in the database personally with the sheriff of the county in which you reside 10 days after release from jail. If you are out of state offender, you must enroll in the database personally with the sheriff of the county in which you reside or occupy a dwelling within 10 days of either 1, residing in or occupying a dwelling in Ohio for more than 3 consecutive days, or 2, residing in or occupying a dwelling in Ohio for an aggregate period in a calendar year of 14 or more days. You are required to provide the sheriff with certain information, including your full name and any aliases you use, your residence address, your social security number, any driver's license or commercial driver's license or state identification card number issued to you, information regarding the offense of which you were convicted or pleaded guilty, the name and address of any place where you are employed, the name and address of any school or institution of higher education you attend, the license plate number of each vehicle owned or operated by you or registered in your name, the vehicle identification number of each vehicle and a description of each vehicle, a description of any scars, tattoos, or any distinguishing marks on your person. You are required to provide the sheriff fingerprints and palm prints. The sheriff will also obtain a photograph of you at the time of enrollment. After the original date of enrollment, you are required to re-enroll annually. You must update and or amend any of the information described above that has changed and provide any information requested at the county sheriff's office within 10 days of the anniversary of the calendar date of which you initially enrolled. If you change your residence address during the 10-year enrollment period, you shall provide written notice of the change to the sheriff with whom you most recently enrolled, and to the sheriff in the county in which you intend to reside within 3 business days of the change of address. You are required to comply with all the above described requirements for a period of 10 years, unless your sentencing court determines otherwise. Since you are, it's blank as to where you reside, but you'll have to, upon your release from prison, you'll have to go to the county which you intend to reside. If it's Cuyahoga, you come to the Justice Center or where the Sheriff's Department jail is located. Failure to enroll or failure to verify residence at the specified times will result in criminal prosecution. And it says here that you acknowledge the above requirements have been explained to you, and that you understand the requirements, and that you will abide by all the provisions of the revised code chapter 2903.41 through 2903.44. And I see here what's indicated as your signature, and it's dated 6/12/23. Mr. Washington, is that your signature towards the bottom of the page?
Yes.
Okay, and I will now sign this document and see that it is delivered to the Sheriff's Department. Mr. Partlow, anything that you want to say on the misdemeanor case?
I'm sorry, did you impose a sentence on your EOA?
Yeah, I did. 10 years. Oh, I did?
You didn't say the years.
Oh, it's 10 years on the RDO.
The only other thing that you said we would address it would be the appeal.
Yeah, okay. So I'm going to, on the misdemeanor, I'll give him credit for time served, okay? So that case will be, I'll waive fine, fees, and costs on that. He receives 438 days of jail time credit while he was in county jail, which will go against his sentence when he's received by the institution. Sir, it is also incumbent upon me to advise you of your appellate rights, and yet you have a right to an appeal of this conviction. Sir, do you want to have an appeal?
Yes.
Okay. And I am in receipt of affidavit, which I'm going to accept for purposes of declaring that the defendant is indigent. Sir, is it a fair statement to say that you will be unable to pay the cost of the appeal?
Yes.
Okay. Is it a fair statement to say you will be unable to obtain counsel for an appeal?
Yes.
Okay. And it's so counsel will be appointed for you without cost. Is it a fair statement to say that you are unable to pay the cost of documents necessary to an appeal?
Yes.
The documents will be provided for you without cost. And that you have a timely right that a notice of appeal be timely filed on your behalf. So the court will go through the process of finding counsel and file a journal entry by the close of today indicating appellate counsel.
Your Honor, I would like to state for the record, I've been involved in 1,000 appeals. I have no problem being appointed in this case.
Okay, great. I appreciate that. We have a list that we use here in Cuyahoga County. Are you on the list?
I used to be, if I still
Yeah.
am not.
I'll check and see, I'll take a look at that, but it'll come from the list. Okay. Let's see. Oh, the last thing I wanted to say is that before I did come into court, I did review both the defendant's sentencing memorandum and the state of Ohio sentencing memorandum that's coming into this sentence. So I think that the way I sentence it, it should be 38 years to life, okay? And for the consecutive sentencings that I imposed, there's 3 different ones that I think that are relevant that I discussed in the entry. And Mr. Washington, all I can say to you is that it's a sad day that we had to go through here, or a sad couple of weeks, the process of your trial. And I wish you well in prison. That's all I can say. All right? Anything further from the state of Ohio?
No, Your Honor, thank you.
Anything further, Mr. Paul?
No, Your Honor.
Well, thank you so much. Okay. So the sheriff can take the defendant and send him down to the Lorraine Correctional Institute for his institution.
All rise.